Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Please like, subscribe, and click the notification bell so you can be updated every time we upload new content. Question number 1. Abel entered into a written contract with Baker to sell Greenacre. The contract was dated June 19th and called for a closing date on the following August 19th. There was no other provision in the contract concerning the closing date. The contract contained the following clause: subject to purchaser Baker obtaining a satisfactory mortgage at the current rate. On the date provided for closing, Baker advised Abel that he was unable to close because his mortgage application was still being processed by a bank. Abel desired to declare the contract at an end and consulted his attorney in regard to his legal position. Which of the following are relevant in advising Abel of his legal position? 1. Time of the essence. 2. Parole evidence rule. 3. Statute of frauds. Or 4. Specific performance. Here are your 4 choices. A. 1 and 3 only, which are time is of the essence and statute of frauds. B. 3 and 4 only, which are the statute of frauds and specific performance. C. 2, 3, and 4 only, parole evidence rule, statute of frauds, and specific performance. Or D. All of the above, time of the essence, parole evidence rule, statute of frauds, and specific performance. Take 10 seconds and choose the best option now. If you chose option D, all of the above, you'd be correct. Time is of the essence is a clause in a contract that means that performance by one party at or within the period specified in the contract is necessary to enable that party to require performance by the other party. Parole evidence is a substantive common law contract rule that governs when a party to a written contract can present extrinsic evidence to disclose an ambiguity and or clarifies it or adds to the written terms of the contract. Statute of frauds refers to the requirement that certain kinds of contracts be memorialized in the signed writing with sufficient content to evidence that contract. Specific performance is an order of a court, which requires a party to perform a specific act. In this case, Abel entered into a written contract with Baker to sell Greenacre. That was conditioned on Baker obtaining a satisfactory mortgage at the current rate. By the date for closing, however, Baker's mortgage application was still being processed. By process of elimination, it is extremely helpful generally to use in most questions. On this matter, we know for certain that time is of the essence, so as a result, options B and C are essentially eliminated. Now, between A and D, which are your only remaining options, we know that the parole evidence rule would also be relevant since there was no other provision in the contract concerning the closing date, which means that the contract is in fact ambiguous. As such, D would be the correct answer, all of the above. Question number 2. A kidnapping statute in State A makes it a crime for a person, including a parent, to take a child from the custody of his custodial parent, knowing he has no privilege to do so. After a bitter court battle, Anne and Dave were divorced, and Anne was given custody of their daughter, Maria. Dave later moved to State B, where he brought an action to obtain custody of Maria. A local judge awarded him custody. His attorney incorrectly advised him that under this award, he was entitled to take Maria away from Anne. Dan drove to State A, picked up Maria at her preschool, and took her back to State B with him. He was indicted for kidnapping in State A, extradited from State B, and tried. At trial, he testified that he had relied on his attorney's advice in taking Maria, and that at the time he believed his conduct was not illegal. If the jury believes his testimony, David should be A. acquitted because he acted on the advice of an attorney, B. acquitted because he lacked the necessary mental element of the crime, C. convicted because reliance on an attorney's advice is not a defense, or D. convicted provided a reasonable person would have known that the attorney's advice was erroneous. Take 10 seconds and choose the best answer now. If you chose option B, acquitted because he lacked the necessary mental element of the crime, you'd be correct. The 4 elements of a crime consist of a guilty act, a guilty mind, concurrence, and causation. In this case, a kidnapping statute of State A makes it a crime for a person, including a parent, to take a child from the custody of his custodial parent, knowing he has no privilege to do so. The guilty act would be taking a child from the custody of his custodial parent. The mens rea required by the statute is knowing. As such, to be found guilty of committing this crime, Dave must have had knowledge that he was taking Maria without a privilege to do so. Therefore, if the jury believes Dave's testimony, he should be acquitted because he lacked the necessary mens rea. Question number 3. Roland, an automobile dealer, had an adult daughter, Betsy, who needed a car in her employment but had only $3,000 by which to buy one. Roland wrote to her, "Give me your $3,000 and I'll give you the car on our lot that we have been using as a demonstrator." Betsy thanked her father and paid him the $3,000. As both Roland and Betsy knew, the demonstrator was reasonably worth $10,000. After Betsy had paid the $3,000, but before the car had been delivered to her, one of Roland's sales staff sold and delivered the same car to a customer for $10,000. Neither the salesperson nor the customer was aware of the transaction between Roland and Betsy. Does Betsy, after rejecting a tendered return of the $3,000 by Roland, have an action against him for breach of contract? A. Yes, because Roland's promise was supported by bargain for consideration. B. Yes, because Roland's promise was supported by the moral obligation a father owes his child as to the necessities of modern life. C. No, because the payment of $3,000 was inadequate consideration to support Roland's promise. Or D. No, because the salesperson's delivery of the car to the customer made it impossible for Roland to perform. Take 10 seconds. If you chose option A, you'd be correct. Yes, because Roland's promise was supported by a bargain for consideration. Consideration is the bargain for exchange between the parties. Consideration is present anytime promises with value of performance are exchanged. Any legal detriment or forbearance, as well as actual benefits in performance, can in fact constitute consideration. The adequacy of consideration is generally not an issue in contract law, because courts do not inquire into the adequacy of consideration. Here, Roland promised to give Betsy a car in exchange for $3,000. Betsy then paid Roland the $3,000. Roland's promise is enforceable since it is supported by the bargain for consideration of $3,000 from Betsy. As such, Betsy has an action against Roland for breach of contract because Roland's promise was supported by a bargain for exchange. Question number 4. A threatening telephone call that purports to be from defendant to witness is most likely to be admitted against defendant if A. The caller identified himself as defendant. B. Witness had previously given damaging testimony against defendant in another lawsuit. C. Witness had given his unlisted number only to defendant and a few other people. D. Witness believes that defendant is capable of making such threats. Which do you believe the best option? Take 10 seconds. If you chose option C, you'd be correct. Witness had given his unlisted number only to defendant and a few other persons. Evidence is logically relevant if it has a tendency to make the existence of any fact that is of consequence to the determination of the action more or less probable than it would be without the evidence. Irrelevant evidence is inadmissible as a result, and relevant evidence might be admissible. In this case, the fact that defendant is one of a few people who know witness's phone number tends to make it more probable that defendant is indeed the caller. For this reason, this is the fact that most supports admitting the threatening telephone call into evidence against defendant. Question number 5. Electco operates a factory that requires the use of very high voltage electricity. Paul owns property adjacent to the Electco plant, where he has attempted to carry on a business that requires the use of sensitive electronic equipment. The effectiveness of Paul's electronic equipment is impaired by electrical interference arising from the high voltage currents used in Electo's plant. Paul has complained to Electo several times with no result. There is no way that Electco, by taking reasonable precautions, can avoid the interference with Paul's operation that arises from the high voltage currents necessary to Electco's operation. in Paul's action against Electco to recover damages for the economic loss caused to him by the electrical interference, will Paul prevail? A, yes, because Electco's activity is abnormally dangerous. B, yes, for loss suffered by Paul after Electco was made aware of the harm its activity was causing to Paul. C, no, unless Electco caused a substantial and unreasonable interference with Paul's business. Or D, no, because Paul's harm was purely economic and did not arise from physical harm to his person or property. Take 10 seconds and choose the best answer. The best answer would be C, no, unless Electco caused a substantial and unreasonable interference with Paul's business. A private nuisance is an unreasonable interference with the plaintiff's use and enjoyment of their land. Interference is unreasonable if the harm to the plaintiff outweighs the utility of the defendant's conduct or the harm caused to the plaintiff is greater than the plaintiff should be required to bear without compensation. The interference generally must also be substantial. Here, Electco's high-voltage currents cause electrical interference with Paul's electronic equipment. The electrical interference may be considered unreasonable if the impairment of Paul's electronic equipment outweighs the utility of Electco's factory operation, or if the impairment of Paul's electronic equipment is greater than Paul should be required to bear without compensation. The electrical interference may also be considered substantial if such interference is offensive, inconvenient, or annoying to the average person. As such, Paul will not prevail unless Electco cause a substantial and unreasonable interference with Paul's business. Question number 6. Donald was arrested in Marilyn's apartment after her neighbors had reported sounds of a struggle, and the police had arrived to find Donald bent over Marilyn's prostrate body. Marilyn was rushed to the hospital where she lapsed into a coma. Despite the explanation that he was trying to revive Marilyn after she suddenly collapsed, Donald was charged with attempted rape and assault after a neighbor informed the police that she had heard Marilyn sobbing, "No, please no, let me alone." At trial, the forensic evidence was inconclusive. The jury acquitted Donald of attempted rape but convicted him of assault. While he was serving his sentence for assault, Marilyn, who had never recovered from her coma, died. Donald was then indicted and tried on a charge of felony murder. In this common law jurisdiction, there is no statute that prevents a prosecutor from proceeding in this manner, but Donald argued that a second trial for felony murder after his original trial for attempted rape and assault would violate the double jeopardy clause. His claim is A, correct because he was acquitted of the attempted rape charge, B, correct because he was convicted of the assault charge, C, incorrect because Marilyn had not died at the time of the first trial and he was not placed in jeopardy for murder, or D, incorrect because he was convicted of the assault charge. Take 10 seconds and choose the best answer now. If you chose option A, you'd be correct. Correct because he was acquitted of the attempted rape charge. The rule for felony murder is that if the defendant is not guilty of the underlying felony, the defendant cannot be found guilty of felony murder. Under the Fifth Amendment, there is a right to be free of double jeopardy for the same offense. Once jeopardy attaches, the defendant may not be retried for the same offense within the same sovereign. In this case, Donald was acquitted of rape but convicted of assault. As such, Donald cannot be retried for felony murder using rape as the underlying felony since it would violate the double jeopardy clause. Question number 7. Loomis, the owner and operator of a small business, encourages wellness on the part of his employees and supports various physical fitness programs to that end. Learning that one of his employees, Graceful, was a dedicated jogger, Loomis promised to pay her a special award of $100 if she could and would run 1 mile in less than 6 minutes on the following Saturday. Graceful thanked him and did in fact run a mile in less than 6 minutes on the day specified. Shortly thereafter, however, Loomis discovered that for more than a year, Graceful had been running at least 1 mile in less than 6 minutes every day as part of her personal fitness program. He refused to pay the $100. In an action by Graceful against Loomis for breach of contract, which of the following best summarizes the probable decision of the court? A, Loomis wins because it is a compelling inference that Loomis's promise did not induce Graceful to run the specified mile. B. Loomis wins because Graceful's running of the specified mile was beneficial, not detrimental, to her in any event. C. Graceful wins because running a mile in less than 6 minutes is a significantly demanding enterprise. Or D. Graceful wins because she ran the specified mile as requested and her motives for doing so are irrelevant. Take 10 seconds. If you chose option D, you'd be correct. Graceful wins because she ran the specified mile as requested and her motives for doing so are irrelevant. A unilateral contract is one where the offer expressly demands acceptance by performance. There is only acceptance upon completed performance. Examples of unilateral contracts include rewards, prizes, and contests. Consideration is the bargain for exchange between the parties. Consideration is present anytime promises with a value or performances are exchanged. Any legal detriment or forbearance, as well as actual benefits and performance, can constitute consideration. Here, Loomis promised to pay Graceful a special award of $100 if she could and would run 1 mile in less than 6 minutes on the following Saturday. Loomis had made a unilateral contract offer that Graceful accepted upon running the mile in less than 6 minutes on the day specified. Loomis bargained for Graceful's performance, so Loomis's promise to pay is supported by consideration and is in fact enforceable. Whether Graceful's motive was to run that mile as part of her personal fitness program is completely irrelevant. As such, the probable decision of the court is that Graceful wins because she ran the specified mile as requested and her motives for doing so are irrelevant. Question number 8. In response to massive layoffs of employees of automobile assembly plants located in the state of Ames, the legislature of that state enacted a statute which prohibits the parking of automobiles manufactured outside of the United States in any parking lot or parking structure that is owned or operated by the state or any of its instrumentalities. This statute does not apply to parking on public streets. Which of the following is the strongest argument with which to challenge the constitutionality of this statute? A. The statute imposes an undue burden on foreign commerce. B. The statute denies the owners of foreign-made automobiles the equal protection of the laws. C. The statute deprives the owners of foreign-made automobiles of liberty or property without due process of law. D. The statute is inconsistent with the Privileges and Immunities Clause of the 14th Amendment. Take 10 seconds and choose the best answer. If you chose option A, the statute imposes an undue burden on foreign commerce, you would be correct. Article 1, Section 8 states that Congress has the power to regulate commerce with foreign nations, among the states and with the Native American tribes. If Congress has not acted, a state or local government may regulate local aspects of interstate commerce unless the state-local law discriminates against out-of-staters or places an undue burden on interstate commerce. In this case, Ames enacted a statute that prohibited the parking of automobiles manufactured outside of the United States in any parking lot or parking structure that is owned or operated by the state or any of its instrumentalities. Ames enacted the statute in response to massive layoffs of employees of automobile assembly plants located in Ames. This seems to indicate that the statute was enacted for a discriminatory purpose, but it is unclear whether or not the statute discriminates against out-of-staters. The statute, however, seems to place an undue burden on foreign commerce, infringe on Congress's power to regulate foreign trade, as well as conflict with the one-voice principle of the federal government in foreign trade. As such, the strongest argument with which to challenge the constitutionality of the statute is that the statute imposes an undue burden on foreign commerce. Question number 9. In an automobile collision case brought by Poe against Davies, Poe introduced evidence that Ellis made an excited utterance that Davies ran a red light. Davies called Witt to testify that later Ellis, a bystander now deceased, told Witt that Davies went through a yellow light. Witt's testimony should be A. Excluded because it is hearsay not within any exception. B. Excluded because Ellis is not available to explain or deny the inconsistency. C. Admitted only for the purpose of impeaching Ellis. or D, admitted as impeachment and as substantive evidence of the color of the light. Take 10 seconds. The correct answer would be C, admitted only for the purpose of impeaching Ellis. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. The hearsay exemptions generally are admission of a party opponent, vicarious party admissions, and prior statements by the witness. The hearsay exceptions are excited utterance, present sense impression, present state of mind, statements of past or present mental or physical condition made for medical diagnosis or treatment, business records, public records exception, and judgments of previous conviction. A witness may be impeached with evidence of a prior inconsistent statement to contradict the testimony of the witness by undermining their credibility. Witness testimony is hearsay, and it does not fall within any of the hearsay exceptions, so it cannot be introduced to prove the truth of the matter asserted. It can, however, be introduced as a prior inconsistent statement of impeachment against the evidence that Ellis made an excited utterance that Davies ran the red light. Our final question of this grouping, question number 10. Owen, the owner of Greenacre, a tract of land, mortgaged Greenacre to ABC Bank to secure his pre-existing obligation to ABC Bank. The mortgage was promptly and properly recorded. Owen and Newton then entered into a valid written contract for the purchase and sale of Greenacre, which provided for the transfer of a marketable title free of encumbrances. The contract did not expressly refer to the mortgage. Shortly after entering into the contract, Newton found another property that much better suited her needs and decided to try to avoid her contract with Owen. When Newton discovered the existence of the mortgage, she asserted that the title was encumbered and that she would not close. Owen responded by offering to provide for payment and discharge of the mortgage at the closing from the proceeds of that closing. Newton refused to go forward, and Owen brought an appropriate action against her for specific performance. If the court holds for Owen in this action, it will most likely be because A, the mortgage is not entitled to priority because it was granted for pre-existing obligations. B, the doctrine of equitable conversion supports the result. C, Owen's arrangements for the payment of the mortgage fully satisfied Owen's obligation to deliver marketable title. Or D, the existence of the mortgage was not Newton's real reason for refusing to close. Take 10 seconds. Choose the best answer. I hope you ended on a good foot and got this right and chose C, Owen's arrangements for the payment of the mortgage fully satisfied Owen's obligation to deliver marketable title. A land sale contract usually precedes the actual transfer of the land. Even if the contract is silent as to the quality of title, there is an implied promise by the seller that at the closing the title is free from reasonable doubt, lawsuits, or threats of lawsuits. A title is unmarketable if any part of the land is subject to adverse possession, encumbrances such as servitudes or a mortgage, or there are any zoning violations. However, the seller must use the proceeds of the sale to pay off any outstanding mortgage at closing. In this case, the Owen-Newton land sale contract provided for the transfer of a marketable title free of encumbrances. Although the contract did not refer to the Greenacre mortgage, Owen had until closing to free Greenacre from the mortgage encumbrance. Owen's offer to pay off the mortgage at closing from the proceeds of the closing would have made Greenacre's title marketable as described in the Owen-Newton contract. Thus, if the court holds for Owen in this action, it will most likely be because Owen's arrangements for the payment of the mortgage fully satisfied Owen's obligation to deliver marketable title. Thank you again for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. Good luck.